closely at this animal. If asked to define it, you would likely describe a living, breathing companion. But if you ask the legal system, the answer is rigid and precise. This diagram illustrates the strict ontological binary that forms the architecture of common law. Every entity on Earth falls into one of two categories. You are either a subject of rights, known as a legal person, or an object of rights, known as legal property. There is no middle ground. A legal person is an entity capable of holding and exercising rights. Naturally, a human being serves as the baseline example. Legal property is an inanimate object over which humans assert rights of possession, custody, and control. Think of a chair or a toaster. Here is where the legal friction begins. In jurisdictions ranging from India to Singapore, animals are legally classified as mere chattel. They belong in the exact same category as your household appliances. This creates a striking paradox. The law dictates that you own a dog in the exact same legal sense that you own a toaster. This framework renders animals highly susceptible to objectification, requiring their interests to be weighed directly against human convenience. This strict binary is currently colliding with a scientific consensus regarding a specific biological reality, sentience. Sentience is defined strictly as the capacity for an entity to consciously perceive subjective causative and negative experiences. These subjective experiences are not abstract. They encompass complex psychological capacities, including profound joy, fear, emotional distress, and long-term trauma. Contrast this biological reality against the legal status quo. An inanimate piece of property cannot experience psychological trauma, yet the law treats an animal as if it possesses the exact same internal state as a piece of furniture. Maintaining this legal fiction, ignoring the internal, conscious state of a living being, creates a deep disconnect between science and the law. The legal system is currently attempting to bridge this gap by establishing an intermediary category between biological reality and legal property. To see how this property paradigm manifests in actual legislation, look at India's Prevention of Cruelty to Animals Act, or PCA. The PCA is a 1960 statute that establishes basic duties of care and prohibits the infliction of unnecessary suffering. Because animals are classified as state property under this paradigm, recent Supreme Court directives regarding the relocation of Delhi's stray dogs implicitly reinforced this status. The ruling allowed their removal to unfamiliar environments, overriding their well-being. Similarly, Singapore's Animals and Birds Act, or ABA, a statute which safeguards against animal cruelty and abuse, was originally framed under this exact same mid-20th century property paradigm. This is the property damage paradigm. These traditional laws are strictly reactive. They are designed to punish extreme physical cruelty only after the asset has been visibly damaged. Notice the specific linguistic limitation in these statutes. They focus heavily on preventing unnecessary pain or physical harm, but they lack the conceptual depth to address psychological neglect. We see this disconnect clearly in enforcement. Fines for neglecting a pet often barely cover the resulting veterinary costs, and they are drastically lower than the penalties for active physical cruelty. As long as the law views animals merely as property to be protected from physical destruction, it will fail to address their mental and emotional needs. This raises a logical question. If property laws fail animals, why not elevate them entirely and grant them legal personhood? This is the explicit goal of many animal rights organizations who seek to remove animals from property status entirely and equate their lives directly with human consequences. However, granting legal personhood carries a severe jurisprudential consequence. It would mean animals possess rights that compete directly and equally with human rights. High courts globally reject this approach. Granting equal rights would instantly destabilize an anthropocentric society, effectively outlying the agriculture, livestock, and scientific research industries overnight. Human utility is deeply embedded in the legal structure. In cultural practices like Jallikattu, property claims and human entertainment legally override the animal's natural prey instincts and terror. Granting full legal personhood is a bridge too far for the current legal framework. A middle path must be constructed. Courts and legislatures are increasingly adopting a middle path known as quasi-property or the property plus framework. The United Kingdom serves as a primary benchmark for codifying this change in status. Passed in 2022, the UK's Animal Welfare Sentience Act explicitly recognizes all vertebrates and certain invertebrates as sentient beings in law for the first time. The Swedish Animal Welfare Act goes even further, asserting that animals have an intrinsic value of their own, regardless of their utility to humans. The foundational mechanism driving this new middle path is the legal duty of care. This diagram shows how a duty of care shifts the legal timeline from reactive to proactive. Under this model, owners are legally required to provide a suitable environment, a suitable diet, and the necessary conditions for the animal to exhibit normal behavioral patterns. This tier resolves the paradox. It retains the human right of ownership, but it attaches severe, legally enforceable psychological and environmental obligations to that ownership. Modern judiciaries, including the Singapore High Court, are internally justifying this transition through what is known as the vulnerability doctrine. The core of this doctrine recognizes that animals possess inherent physiological limitations, existing entirely within a world dominated and ordered by humans. Their ultimate legal disadvantage is that while they are capable of immense suffering, they entirely lack the capacity to alert authorities or avail themselves of legal recourse. As Chief Justice Catherine Fraser noted in Reese v. Edmonton City, they have no capacity to consent to what we do to them. Because animals are acutely vulnerable and lack a voice, offenses against them create deep judicial disquiet, demanding a much higher standard of legal protection. Ultimately, a valid measure of a society's justice system is how it chooses to treat the completely powerless subjects it owns and controls. This brings us back to the impending legal reforms. Reviews of legislation like the Animals and Birds Act seek to align statutory law with biological science. The practical outcomes of this shift include harmonized penalties for psychological neglect, lifetime disqualification orders for animal abusers, and stronger upstream enforcement powers. This transition preserves the distinction between humans and animals rather than granting pets full legal personhood. The law is moving to reflect biological evidence, ensuring that legal status aligns with an animal's capacity to suffer. By moving animals out of the shadows of inanimate property, the law is establishing that our ethical obligations extend beyond preventing damage to our possessions. We are now establishing a framework that guarantees dignity to sentient life.